Mr. Roberts,
My Lord.
do we know why the accused are late?
My Lord, I inquired for the delay. I've been informed that it was a transport problem. Apparently there were more than 40 prisoners to be taken from the prison to the courts.
Yes.
And that was the reason. So the vehicles, they only had 2 vehicles, which meant they had to drive twice to get everybody here. So that was the reason for the delay, my Lord.
But I think it also happened last week, I'm told.
Yes, my Lord. I think it is a matter that needs to be addressed. And the transport is a major problem. They have only 2 vehicles available to transport all the prisoners from the prison.
And there's no money for other vehicles.
Indeed, my Lord.
Yes. I think it's, it's not good.
It is unacceptable, my Lord.
Yes.
I agree.
I'm proceeding with judgment today. The 3 accused between them were charged with 32 counts, which is racketeering, managing an enterprise, intimidation, willful causing an explosion, malicious injury to property, 11 counts of murder, conspiracy to cause murder, 5 counts of robbery with aggravating circumstances, 5 counts of fraud, theft, defeating the cause of justice, possession of unlicensed firearms, and unlawful possession of ammunition. They are also charged with alternative charges to some of the main charges. Count 1. Counts 1 and 2 relates to the existence and managing an enterprise as referred to in the racketeering provisions of the Prevention of Organized Crime Act, number 121 of 1998, and in brackets. Was charged with all 32 charges. Accused 3 was charged with 22 counts, which include 8 counts of murder. Most of the charges carry a minimum sentence in terms of Act 105 of 1997. There were 3 other accused persons who were also charged with most of the charges that the accused in this matter are faced with. LaRue Steyn, and in brackets LaRue, and John Barnett, and in brackets Barnett, had entered into plea bargains in terms of Section 105A of the Criminal Law Procedure Act 51 of 1977, and in brackets the CPA, and was sentenced to various terms of imprisonment. Miranda Steyn, and in brackets Miranda, did not enter into a plea bargain, but had pleaded guilty and was also sentenced to various terms of imprisonment. They form part of a group known as electus per deus, which means chosen by God. The accused who were legally represented pleaded not guilty and elected not to give any plea explanations. They were informed that some of the charges contained minimum sentences. The accused made admissions which are contained in Exhibit A in terms of Section 220 of the CPA, which were read into the record. It's not necessary to repeat same. This court had evidence over a 37-day period. The following witnesses were called by the state: LaRue Steyn, John Anthony Barnett, Jakes de Villiers, Charles Truter, Nina Scott Dawkins, Nicholas Meyer, Charles Marius Maynard, Johan van Wyk, Joshua Albertus Groenewald, Candace Ellison, Constable Sibusiso Tabete, Captain Pule Ruben Gadi, Darren Stowe, Aris Rana van Lochenburg, Heather Schofield, Katrina Jacoba Litton, Kezia McAlpine, Nigel Blackmore Reid, Wilson Kedimole Ngoma, Magdalene van Dijk, Andre Lategan, Leanne Lerm, Joanne Vrede, Lana Schroeder, Annemarie Jacoba Scholz, Maria Susanna Volbrecht, Amanda Achenbach, Denise Gail Berger, Esther Elizabeth Skutter, Linda Elizabeth LaRue, Shane Cheskelwitz, Jason Stocko, George Albertus Nell, Ruan Venter, Judith Swanepoel, Conrad Josiah Robertson, Melanie van der Merwe, David Robert Bester, Alfred Robert Odendaal, Ebert Philippus Kleinans, Carrie Ann Lisa Dunning, Daneo Consalda Nkondo, Johannes Bernardus van Art, Barnett L. Engelbrecht, Candace Ridgewick, Constable Chiliboy Metloa, Professor Simon, Maria Johanna Groenewald, known as Ria, Jake Poseidonot, and Captain Colile Lawrence Chongane. The accused testified and accused 2 called Miranda as her witness. 11 people were murdered over a 4-year period from 2012 to 2016. Some of them were also robbed. Due to how this matter had unfolded before me, and especially after accused 3 had decided to come clean when she testified about her knowledge and involvement in most of the incidences, it becomes unnecessary for me to deal with the evidence led in any great detail, except for the versions of accused number 1 and 2, and that of Miranda. It is clear that Miranda testified before this court in an attempt to exonerate accused number 2 and 3 of their involvement in the offences. But those attempts failed dismally after her daughter, accused 3, had a change of heart. There is not much dispute about who, why, and how the murders and the other offences were committed. The only real dispute is what role, if any, accused 1 and 2 played in the commission of the offences, and whether the defence raised by accused 3 of necessity should succeed. The other dispute relates to the murders of Natasha Berger, and in brackets Natasha, and Joy Bonzaier, brackets Joy. That he and Michaela Valentine, in brackets Michaela, had committed this offence, those murders. However, accused 3 testified that after those murders were committed, she was instructed to watch the knife that accused 1 had used in the commission of those murders, which she did. A further dispute is what role, if any, accused 1 had played in the murder of his wife, Michaela, and whether he informed accused 2 that she wanted to move out of the group. Was called as accused 2's witness, and accused 3, who confirmed the versions of Leroux, Barnett, and de Villiers in the main. One of the main issues in this matter is whether the accused formed part of the enterprise, knew about the predicate offences, and participated directly or indirectly in the commission thereof. Before dealing with the evidence, it is appropriate for me to deal with the provisions of POCA. It is important when dealing with POCA to look at its purpose, scope, and objectives. Its preamble states inter alia as follows, and I quote, "And whereas there is a rapid growth of organized crime, money laundering, and criminal gang activities nationally and internationally, and since organized crime has internationally been identified as an international security threat, and whereas organized crime, money laundering, and criminal gang activities infringe on the rights of the people as enshrined in the Bill of Rights, and whereas it is the right of every person to be protected aimed at dealing effectively with organized crime, money laundering, and criminal gang activities, and bearing in mind that it is usually very difficult to prove the direct involvement of organized crime leaders in particular cases, because they do not perform the actual criminal activities themselves. It is necessary to criminalize the management of and related connection with the enterprise which are involved in a pattern of racketeering activity. And whereas the pervasive presence of criminal gangs in many communities is harmful to the well-being of those communities, it is necessary to criminalize participation in or promotion of criminal gang activities." Close quote. It is right that one of the primary purposes of POCA was to create a statutory framework which would make it easier for the state to prosecute certain offences. A National Director of Public Prosecutions and another, versus Mohammed, Nomina Fikir, and others, 2002, Volume 4, SA 8436-843, CC, a judgment of the Constitutional Court. The Court referred to the preamble in emphasizing the importance of POCA to curb the rapid growth of organized crime, money laundering, criminal gang activities, and racketeering, which threatens the right of all in the Republic and presents a danger to public order, safety, and stability, thereby threatening economic stability. In Savoy and Others versus National Director of Public Prosecutions and another, 2014, Volume 1, SACR 545 CC, the court succinctly explained the working of organized crime and stated the following at paragraph 82. Organized crime, and I quote, organized crime works like a modern business and even organizes its structures like those of business entities. Just as a particular business operates in a particular fashion, so does an entity involved in organized crime. It will have a particular mode of operation, and that will be ongoing. Of course, like business, it may diversify or abandon the current category of activities and embark on something new altogether. As business becomes sophisticated, so do the operations of organized crime. Cameron J. in Elrond said the following, and I quote again, the second reason POCA, like legislature, is indispensable is the intricacy and complexity of modern law breaking. No longer is economic crime committed only through romantically imaginable methods like piracy, highway robbery, and smuggled contraband. All that, if not the past, is now through infinitely more sophisticated means, indirect and electronic. More importantly, even it is then concealed through those means, close quotation. It is tried that when considering or construing the provisions of POCA, a liberal or broad construction approach is called for. In this regard, see State versus Prinsloo and Others, 2016, Volume 2, SACR 25 SCA. In State versus De Vries and Others, 2012, Volume 1, SACR 186 SCA, at paragraph 48, the court said that to secure a conviction under Section 2.1, the state must more than merely prove the underlying predicate offences. It must also demonstrate that an accused association with the enterprise and a participatory link between the accused and the enterprise's affairs by means of a pattern of racketeering. It's common cause that in this case, there was a group of individuals, including the three accused, which was known as electus Budaeus, which according to the state was an enterprise and associated through a ministry. The accused disputed that there was a ministry and or an enterprise. It is tried that the state must prove regarding the contravention of Section 2.1f, managing, namely that an enterprise existed, that the accused managed the operations or activities of the enterprise, that a pattern of racketeering activity took place, and that the accused knew or should reasonably have known that a pattern of racketeering activity took place. In State versus Asen, 2009, Volume 1, SACR 406 SCA, the court explained the difference between the offences in subsections E and subsections F as follows, and I quote, the essence of the offence in subsections E is that the accused must conduct or participate in the conduct of an enterprise's affairs. Actual participation is required, although it may be direct or indirect. In that respect, the subsection differs from subsections F, in the essence of which is that the accused must know, or ought reasonably to have known, that another person did so. Knowledge, not participation, is required. On the other hand, subsections E is wider than subsections F, in that subsections E covers a person who was managing or employed by or associated with the activity. The plain wording of the subsection requires mens rea in the form of either dolus or culpa. As explained by Albert Kruger in Organized Crime and Proceeds of Crime Law in South African 2008 edition at page 148, the words ought reasonably to have known introduce the element of reasonableness, which must be assessed objectively. No subject intent or dolus eventualis is required. The question is whether the fictional reasonable person, the diligence pater familias, would have known. See also Jonathan Birchall, Principles of Criminal Law, edition 2014 at 874, close quotation. Culpa would also suffice for a contravention of Section 2.1f of POCA. See also State vs. Prinsloo and Others, supra, at paragraphs 52 to 54, read with Section 1.3 of POCA. With regard to the contravention of Section 2.1e of POCA, the state must prove, as far as accused 2 is concerned, that whilst managing an enterprise, and in brackets the scheme, the accused directly or indirectly participated in the conduct of the scheme's affairs through a pattern of racketeering activity. The essence of the offence referred to in section 2.1e is actual participation, be it direct or indirect, in an enterprise affairs as opposed to knowledge, not participation, which is essence of an offence in terms of section 2.1f. The following is stated at paragraph 64 in Prudence Law, and I quote, "To summarize, it is now well settled law that the essence of the offence in terms of section 2.1e of POCA is participation through a pattern of racketeering activity and not knowledge. Once it's proved that the accused has participated in the conduct of an enterprise affairs through a pattern of racketeering activity, that is by committing two or more predicated offences listed in Schedule 1 of POCA, he or she is guilty of a contravention of section 2.1e of POCA. There is no need for a further inquiry as suggested on behalf of first accused as to an additional mens rea required over and above the mens rea required by the predicate offences." Close quotation. Section 2.2 of POCA reads as follows: "The court may hear evidence, including evidence with regard to hearsay, similar facts, or previous convictions relating to offences contemplated in subsection 1, notwithstanding that such evidence might otherwise be inadmissible, provided that that evidence would not render a trial unfair. The duty of the court in regard to the question of hearsay in relation to the aforesaid section was explained in the matter of Savoy and others supra as follows," and I quote, "There are two more strings to the applicant's bow. Firstly, they argue that because there is no way of knowing in advance what criteria govern the admissibility of otherwise inadmissible hearsay, an accused person cannot anticipate or guard against the inherent prejudice. That is because the section is silent on the criteria. Secondly, they contend that the admission of the evidence is dependent on the discretion of both the prosecutor and presiding judge, with no guidelines on the exercise of that discretion. At first blush, but no further, the first argument appears sound. If the want of criteria were constitutionally objectionable, the Constitution would set criteria for instances where courts have to pass a value judgment on an issue. Well, an example of an instance where there are no criteria and yet courts are expected, should the need arise, to make a judgment call is section 35.5 of the Constitution. The section reads, "Evidence is obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice." This section does not give an indication of circumstances where the admission of what I will loosely call unconstitutional obtained evidence would render a trial unfair or be detrimental to the administration of justice. Also, we know on authority that what is itemized in section 35.3 2.0 does not constitute a closed list. The right to a fair trial is wider. If one uses what is itemized as a mirror to help guide us on what is unfair beyond that mirror, that is outside the list, one cannot anticipate what more would render a trial unfair. The judgment call in each of these instances will turn on what is before the court. Is this objectionable? I believe not. This leads me to the conclusion that there is simply no unfairness or prejudice to an accused arising from the lack of guidelines in sections 35.5, albeit sourced from an Act of Parliament, section 2.2 of POCA, is analogous on the issue complained of. In principle, I do not see why the position should be different. Whether or not the admission of otherwise inadmissible evidence will render a trial unfair is something to be determined by the trial court based on the material before it. The second argument referred to in paragraph 65 above is totally misconceived. Judicial officers are not administrative functionaries. The judgment expected of them in terms of section 2.2 of POCA lies at the heartland of judicial function. Any judicial officer worth her salt should be perfectly placed to make the necessary value judgment. In this context, the reference to an exercise of discretion by a prosecutor is misplaced. What the prosecutor does is to decide on the arsenal to be displayed. In the lineup, there may be evidence in respect of which a prosecutor intends invoking section 2.2 of POCA. It is a trial court that will either admit or reject that evidence. Close quotation. Section 2.2 of POCA must furthermore be construed against the background that it must be accepted that the legislature in drafting Section 2.2 must have been aware of Section 3 of the Law of Evidence Amendment Act, and that the intention was to create a less onerous method for the state to admit hearsay evidence. This is borne out in Savoy and others versus National Director of Public Prosecutions and another at paragraph 47, and I quote, "The Section 2.2 serves a twin purpose. Firstly, it effectively does away with the hearsay rule on charges under sections 2.1 of POCA, and indeed other exclusionary rules. In this respect, the section differs from Section 3.1 of the Law of Evidence Amendment Act, which retains the exclusionary rule, but permits the admission of hearsay evidence only under certain circumstances, set out in paragraphs A to C of the section." Close quotation. Regarding the issue whether the admission of hearsay would be so unfair as to infringe an accused's fair trial right, the court said at paragraph 49 that there was something best left to the trial court. It stated further that there are issues, to mention but a few: the nature of the evidence, its reliability or lack of it, its probative value, and prejudice to the accused would have to be construed. It concluded at paragraph 64 that it was misconceived to suggest that under all circumstances the admission of otherwise inadmissible evidence would automatically result in a trial being unfair in violation of Section 35.3 of the Constitution. It is right that the approach to hearsay evidence in terms of Section 2.2 of POCA, contrary to the exclusionary approach of Section 3 of the Law of Evidence Amendment Act, is inclusionary, and that hearsay evidence is admitted unless it would render the trial unfair. Section 2.2 of POCA relates to the predicate offences, as a conviction in terms of any of the POCA offences not only relies on but encompasses the predicate offences. To argue otherwise would strip Section 2.2 of its intended purpose and cause it to be absolute and of no effect. It is right that fairness is not a one-way street. It is a two-way street. Fairness includes also the state, who represents the public at large. If this is not the case, the administration of justice will quickly fall into disrepute. And in this regard, see National Director of Public Prosecutions versus King, 2010, Volume 2, SACR 146, SCA at 152, from 8 to D. At paragraph 58, the court said the following, and I quote, "There is no such thing as perfect justice. Fairness is not a one-way street, conferring an unlimited right to an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's rights should be subordinated to the public interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make impracticable to conduct a prosecution. The fair trial does not mean a predilection for technical niceties and ingenuous legal stratagems, or encourage preliminary litigation, a pervasive feature of white-collar crime cases in this country. To the contrary, courts should do within the confines of fairness, actively discourage preliminary litigation. Courts should further be aware that persons facing serious charges, and especially minimum sentences, have little inclination to cooperate in a process that may lead to their conviction, and new procedure can offer opportunities capable of exploitation to obstruct and delay. One can add the tendency of such accused, instead of confronting the charge, of attacking the prosecution." Close quotation. So the starting point in terms of Section 2.2 of POCA is that the hearsay evidence would be admissible unless it's shown that its admission will render the trial into an unfair trial. Mere speculation that the admission of the evidence may result in an unfair trial does not satisfy the criteria, and there will need to be a proper basis showing not mere possible prejudice, but actual prejudice resulting in an unfair trial. Because there is direct evidence as well as circumstantial evidence in respect of most of the charges, the hearsay evidence would simply serve as a supporting role. The prejudice that the accused may suffer in those circumstances, if the hearsay evidence is admitted, is therefore, if not totally done away with, at least minimized to such an extent that its admission would not render the trial unfair. The approach in respect of a fair trial has been set out in State vs. Jail Paul, 2005, Volume 1, SACR 215, CC at paragraph 29 as follows, and I quote, "The right of an accused to a fair trial requires fairness to the accused, as well as fairness to the public as represented by the state. It has to instill confidence on the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of the crime. At the beginning of the trial, I had ruled in terms of Section 2.2 of POCA that the hearsay evidence was admissible, albeit provisional. I was mindful of the various decisions of our courts when I made the aforesaid finding or ruling, which I now rule to be final with one or two exceptions. None of the counsel for the accused could point out how the admission of the hearsay evidence in this matter would render the trial unfair. They were invited to do so, but could not. It is clear from the evidence led that the hearsay evidence that I'd allowed was confirmed in the main by accused number 3, and would not render the trial as unfair. Accused 1 and 2 had denied any involvement in any of the counts that they are faced with. It is the state's case that accused 2 played a central role in the lives of the accused and some of the witnesses and people that she had met. All of them were told by accused 2, who denied this vehemently, that she was a former Satanist, was a 42nd generational witch, could do astral traveling, read people's minds, walk on water, that there was an orphanage where all the firstborn children of members of the Satanic Church had kept their children, who did not want them to be sacrificed, that she was a born-again Christian and was the bride of Satan. Some of the crucial witnesses, except for Miranda, testified that accused 2 played a central role in all the offences that had taken place. The offences were planned by accused 2, and after the offences were committed, there would be a report back to her. Miranda testified that accused 2 was not involved and that members of the group went on a frolic of their own when they went about committing the various offences, and at no stage was there any planning and report back to accused number 2. Before dealing with the individual charges, it is necessary for me to give an outline of the evidence laid before me and a history of the tragic matter where 11 innocent people were murdered and so many families, including witnesses and some accused, were negatively impacted. This is a matter of religious manipulation, deceit and lies, where Christianity was brought into disrepute. It is a matter involving the forces of darkness versus the forces of light, a matter involving evil against good, a matter involving someone who had claimed to be a 42nd generational witch with supernatural powers as being the most powerful witch on earth, who had unleashed a reign of terror on people who did not share her vision of what true Christianity is, and had in the process used genuine people who wanted to make a difference and believe what they were told came from God and that it was for a greater and good cause. This matter is a sober reminder of the dangers that genuine religious people are faced with, who are sometimes manipulated by their religious leaders, who would quote certain portions of their holy books to further their evil and criminal aims and activities. It is almost like this powerful witch on earth had cast a spell and had hoodwinked people in believing what they were told. It's almost like she had cast a spell on them which made them to blindly follow her. I simply fail to understand how all the accused who had professed to be born-again Christians could so brutally and carelessly murder people and would thereafter merrily carry on with their lives. The timing of the events giving rise to the charges is significant. The history leading up to the commission of those offences provides not only a motive, but more significantly, defining circumstantial evidence in which those offences must be considered. The state's case is supported by direct evidence and circumstantial evidence. Issues that will arise include hearsay evidence, the doctrine of common purpose, and the defence of necessity or compulsion. The history of this matter, let me repeat, the history of this tragic matter goes back to 2007, when Ria started a Christian ministry which was called Overcomers Through Christ, and in brackets OTC. She was the leader of the OTC. Ria had attended courses hosted by F.H. Havenger on Satanism in Kempton Park with Pastor Nell's wife. As a result of the courses that she had attended, she started speaking at various schools on the dangers of drugs and Satanism. Her work at the schools was sponsored by Pastor Nell. At the same time, Ria also presented the course called Know Your Enemy, and in brackets KYE, to people who wanted to know more about the inner workings of the occult. In the process, she also assisted people who wished to be delivered from occult bondage. She later was informed by a former Satanist who had come out of the satanic cult. She then met the former Satanist who is accused number 2. She was informed that accused 2 needed help to escape the satanic church and who required protection from spiritual attacks, more specifically during what was referred to as satanic high days. Various people attended the KYE courses, some of whom subsequently also became involved with Ria's ministry in respect of accused number 2. All of those people who had met accused 2 believed that she was a former Satanist. She had elicited a lot of sympathy from caring people who had believed in what they had been told by her. Ria also believed that accused 2 was a former Satanist. Due to accused 2's professed experience and knowledge of the occult, Ria requested her to compile a training manual, which later formed part of the training material handed out to KYE coursegoers. Unbeknown to her, accused 2 had solicited the assistance of Candace Ridgewick, who had done research on the internet and gave it to accused 2 for her final approval, and she had the final say in respect of the contents thereof. Not only were the acknowledgement done by accused 2, but the training manual also bore the email address of accused 2, which specifically referred to one of her DID parts, namely Zina. Ria had used accused 2 as an example of the person who had come out of the satanic world. Ria would also incorporate information she heard from and experienced with accused 2 in a presentation as part of the KYE. At the stage, the attention demanded by accused 2 of Ria reached such a point that Ria, who originally stayed in Roodepoort, had to move close to accused 2, and she moved in at Drama Court in close proximity of Kosanaflats, Krugersdorp. Some of the attendants at Ria's course also met accused 2 through Ria. These included Miranda, who is the mother of accused 3, and LaRue. They had met her in 2007, or beginning of 2008. Accused 1 and his wife Michaela also met her, and accused 1 realized that he had known her when they were still attending school at Western Area and had attended youth at the Western Area Baptist Church. Ria's whole life started revolving around accused 2, and she spent most of her available time at accused 2's flat. Ria would be working during the day, once at night, looking after accused 2, sleeping on the couch in the sitting room. At some stage, Ria moved into accused 2's flat and slept on the single bed in a bedroom. Whilst Ria was looking after accused 2 by night, other persons would be looking after accused 2 during the day. These people included Candace Ridgewick, Michaela, specifically on Thursdays, Arana van Lochrenberg, and Miranda after school, as well as LaRue and accused number 3. Almost all of the witnesses who had known accused 2 had believed her when she said she had spiritual powers. All of them were told about a non-existing orphanage where the children of former Satanists were hosted. Money was needed for the orphanages, but no one knew or had seen where those orphanages were based. On specific satanic high days, as determined by the satanic calendar, Ria and other members of her group would congregate in the early evening in accused 2's flat at One Kosana flat. Normally, normal Christian gospel music would be played, not only in preparation for the evening, but also throughout the events of the evening. Accused 2's bedroom would be sealed off with some oil as a spiritual sign of protection. A shofar and or kudu horn would also be blown as part of a spiritual act and or declaration. At some stage during the evening, accused 2 would be attacked in the spirit by unseen demonic forces, which exhibit itself to the extent that she would lose consciousness and or act out in a physical body and or cough blood. An integral part of the evening would then be taken up by spiritual warfare, which took the form of constant and continued prayer, declarations of spiritual and biblical truths, and sometimes the shielding of accused two's orifices with hands covered in oil to prevent spiritual invasion of her body. The constant spiritual protection of accused two under the guidance of Ria and with the help of various other individuals essentially became a ministry on its own. But then the tide started turning. At some point, Ria introduced a new course called Know Your Savior, and in brackets KYS, which came into existence as a result of persons who previously completed the KYE course and wanted to obtain a deeper understanding of certain spiritual truths. Accused 2 did not form any part of this course and was not allowed to attend it. This course, as opposed to KYE, did not focus on the occult. More or less at the same time, Ria had taken a decision to sever her ties with Accused 2, as there were various issues Accused 2 did that did not sit well with Ria. This led to certain individuals siding with Accused 2, to wit, Accused 1, Michaela, and Miranda, together with her children, LaRue, and Accused number 3. Barnett joined Accused 2's group later on. At some stage, the KYS course was presented at Ria's flat at Drama Court. Various incidents happened involving different members of the group attending Ria's courses. Once, Pastor Joel Snell's motor vehicle was broken into. Another incident involved the damaging of Natasha's motor vehicle's tires, resulting in a blowout whilst driving on the highway. The last incident at the Drama Court involved an incident where Nigel Blackmore Reid was held up at gunpoint. Accused 2 and Miranda were present in the vicinity of the scene of the incident. Accused 3 had changed the rechargeable batteries of a tracking device that was fitted into Ria's car. Once Ria had withdrawn from Accused 2, all the incidents aimed at Ria and her followers started happening. As a result of these incidents at Drama Court, a decision was taken by the group to move the venue of those meetings to 11 Kelly Street, Noordheuwel. The first meeting at 11 Kelly Street went on without any incident. However, during the second meeting on 4th July 2012, packets of fertilizers were placed under the wheels and petrol poured over the vehicles of the attendees. Before the petrol could be ignited, the perpetrators were interrupted and fled the scene. The following week, on 11th July 2012, the meeting, which was also attended by Reginald Bendixson and in brackets Bendixson, and Natasha, was again interrupted by various explosions being set off inside the yard where the attendees' vehicles were parked. This time, substantial damage was caused to the motor vehicles. Only one further meeting was held at yet again a different venue, where it was decided by the group that it had become too dangerous to continue with the KYS course, and it was decided to cancel the course with immediate effect. Ria was so shaken by the events and concerned about the safety of the other members of the OTC and those who attended the courses that she immediately terminated all her ministry work and courses so as to protect them from further harm. On 15 July 2012, an incident happened at the Lighthouse Church in Randburg, where Pastor Nell was the pastor. During the incident, a fire started at the church at night, resulting in substantial damage. Pastor Nell was associated with Ria, which was personal and direct. Firstly, Ria and his wife had attended a training course presented by Havenger. Secondly, Pastor Nell originally sponsored Ria's ministry work at the schools. Thirdly, Pastor Nell attended some of the training meetings at Ria's flat at Drama Court. And fourthly, Ria frequently attended his church services in Randburg. Most importantly, a handwritten letter, apparently intended for the attention of Ria, was found at the church's gate with words to the following effect. And I quote, "Ria, who's going to protect you now?" Close quotation. Pastor Nell's son, Vincent, was specifically mentioned in one of the threatening messages as one of the multiple possible victims. Approximately 2 weeks later, on 26 July 2012, Natasha and elderly friend and close-by neighbor, Joy, were murdered at their residence at Lancet Complex, Villa Park. Natasha was, by all accounts, very committed to the OTC, to the extent that she became a second in command to Ria and followed in Ria's footsteps at the beginning to present KYE courses herself. She was murdered because she had prayed the dangerous prayers, which allegedly led to the death of children by witches of the Satanic Church. These murders, according to the evidence of LaRue, as corroborated by Miranda, were committed by accused 1 and Michaela. Accused 3 testified that she had also participated during a prior unsuccessful attempt, where she had to gain entrance to Natasha's flat with the intent of immobilizing her with a taser gun, and went there on the pretext of looking for a missing cat, but was not allowed into the premises. She also said that she had to rinse off the knife that accused 1 had used with Chick. The cause of death of Natasha was multiple stab-incised wounds to the neck. She had sustained 17 stabbing wounds. The cause of death of Joy was stab-incised wounds of the neck. She had sustained 6 sustained wounds, and the reports noted that there were no defensive injuries on the body. Less than 3 weeks later, on 13 August 2012, Ben Dixon was murdered at his house. The association between Ria and the murdered Ben Dixon was a close one. Ria's cause, KYS, was inter alia based on some of the teachings of Ben Dixon. Consequently, he was invited to give an ad hoc lectures as part of the Ria's KYC course. He was also a friend of and spiritual mentor of Ria. This murder was committed on the evidence of LaRue and as corroborated by that of Miranda by accused 1 and Miranda, both of whom were closely associated with accused 2. Accused 3 explained in detail that the decision was taken by accused 2 that Ben Dixon had to be murdered because of a sermon being used by him, as if he was the author thereof. She went further and confirmed that she knew about the threatening letters with pieces of meat at Ria's front door on the day of Ben Dixon's funeral. She identified the handwriting on the letter to be that of accused 2, and that the meat coming from a pig's head, which was brought for practicing their stabbing techniques. The prime idea was once again to threaten and intimidate Ria. Accused 3 was also present when he was murdered. The cause of his death was determined to be multiple stab wounds to the body. He had sustained 9 stab wounds and a fracture of his skull. Approximately 2 months later, on 4th October 2012, Michaela, the wife of accused 1, was murdered. According to the evidence of Miranda, she executed the actual killing with full knowledge and prior assistance of accused number 1. According to LaRue, accused 3 was accompanied by Miranda and even got 1 stab in. She confirmed accused 1's involvement in that he had to spike Michaela's drink. The plan was to stage this killing as part of a housebreaking, which went wrong. The killing was committed by persons intimately associated with accused 2. In this instance, the motive for the killing of Michaela 2 was the express wish to withdraw from the group and its ongoing criminal activities. She did not only express it to accused number 2 and 1, but also to her mother and friends, Charles and Yonita. Her intimate knowledge of and personal involvement in the aforementioned criminal activities of the group made her a liability for the group, and was also referred to as a loose end, and all its members, as there was a risk of her having become disillusioned, splitting on them and going to the police. She died of multiple incised penetrating wounds and blunt force trauma to the head. She had sustained 50 incised wounds. In July 2013, the group conspired to kill Joshua Groenewald, the son of Ria. Except for being the son of Ria, he had absolutely nothing to do with accused 2's group. This was to take revenge on Ria and to hurt her by killing individuals close and dear to her. Accused 3 stated that it was part of the bigger scheme to get to Ria. Again, the conspiracy was committed by various individuals closely related to accused number 2, to wit, LaRue, accused 1, Miranda, and accused 3. This was also seen as a test of loyalty of Jakes de Villiers and Brex de Villiers to the group, as he had to prove himself. De Villiers testified that he was an unwilling participant who acted under duress. He actively attempted to prevent the actual murder and even agreed to record one of the group's meetings so as to obtain evidence for a possible prosecution against other members of the group. Soon thereafter, he decided to break off ties with the group and disappeared. The people who were close to accused number 2, who had a change of heart and decided to disappear timelessly, are still alive today. This is true for Candace Ridgewick, Miranda van Lochenberg, de Villiers, and Ria. The second set of murders also had a distinct and mild and unique context and motivation. On the state's version, accused 2 at all relevant times brought the people around her under the impression that she was looking after and caring for various victims of occult persecution, including an orphanage for children of satanic witches. To this cause, various individuals contributed shockingly large amounts of money to accused number 2. On accused 2's version, no such orphanage existed, and she could not give a credible explanation for receiving those contributions. According to accused 1, he gave accused number 2 over 2 million rands over a period of 2 to 3 years. Candace Ridgewick, prior to accused 1's involvement with accused 2, also gave huge amounts per month to accused 2, in a single month as much as 100,000 rands. Even Barnett took out a personal loan, of which an amount of 30,000 was given to accused number 2 in support of the orphanage. Accused 2 was not only dependent on external sources of income to sustain a lifestyle, but was used to large amounts of mostly cash, which she received on a monthly basis from those external sources. Accused 1 resigned from his well-paying job at Discovery, as a result of which he no longer had a regular income. That directly impacted on accused 2's stream of income. Therefore, as from November 2015, accused 2 set a new goal for the group by instructing the members of the group, as per the evidence of LaRue, Barnett, and accused 3, to seek new income. This new goal would be pursued through illegal activities and the commissioning of crimes. The first of such attempts to achieve their new goal was the robbery and inevitable murder of Peter and Joan Meyer. These murders and robbery were committed by persons closely related to accused 2, being Miranda, accused 1, and accused 3. Barnett and LaRue were initially fully involved in the planning. Since LaRue was in hospital and Barnett had arrived late from work on the day when they were murdered, accused 3 accompanied them to the crime scene. Whilst Peter Meyer was being murdered, he recited Psalm 23. His cause of death was determined to be multiple penetrating incised wounds. He had sustained 15 stab wounds involving the face. The cause of death of Joan Meyer was determined to be multiple penetrating incised wounds. She had sustained 24 stab wounds. The Meyer robbery, being a total failure in the sense that only 600 rands was robbed, led to the next scheme that was put into place to obtain money. It was an elaborate plan to fake the death of accused 1 and to claim the benefits from his life insurance policy, which according to accused number 3 was suggested by accused 1. Accused 2 had already been made the sole beneficiary of accused 1's life policy for the total insured amount of 3.57 million rands. Not only were the perpetrators closely associated with accused 2, but in this instance, also the deceased Jared Jackson, and in brackets Jared, who prior to his demise had sustained contact or had substantial contact with accused 2, and also stayed in the storeroom for a period of time. Jared was requested by accused 1 and the group to accompany him, or to accompany accused 1 on a trip. He got into the front passenger seat of accused 1's BMW, which was driven by accused 1. LaRue sat at the rear seat of the BMW behind Jared. Jared's drinks had earlier been laced with sleeping tablets by LaRue and accused number 2. After he started falling asleep, he was strangled by LaRue. At some point in time, the BMW vehicle was stopped and he was placed into the front passenger seat of accused number 1's Mercedes-Benz SLK, which was driven by Miranda. The Mercedes-Benz was driven for a short while, and he was then moved to the driver's seat. It was set on fire with him being behind the steering wheel. Accused 1 was then taken to the Herberg Hotel on the pretext that he was deceased and had made use of a forged identity document of the Villiers. There were some delays in the paying out of the life cover that accused 1 had taken out for accused 2, and money was needed by the group, allegedly for the orphanage. Various people who were assumed to be wealthy were identified, and plans were hatched by the group to kill them. The 4 appointment murders were similarly committed by Miranda, LaRue, accused 3, and Barnett, all of whom were closely associated with accused 2. According to LaRue, Barnett, and accused 3, all the robbed money was handed over to accused 2. The first person who was identified was Glenn Keith McGregor, who was murdered on 26 January 2016. Miranda was accompanied by Barnett, LaRue, and accused 3. He was shot twice by Miranda, and accused 3 assisted LaRue by placing his body into a bathtub that was filled with water. An amount of 6,000 rands was transferred into Miranda's account. He died of gunshot wounds of the abdomen. 3 other persons were murdered on separate dates at 17 Kosana Flat by Miranda, LaRue, Barnett, and accused 3. The same modus operandi was used. The victims would be invited to 17 Kosana Flat. Accused 3 and Barnett would be playing loud music in the bedroom, whilst LaRue and Miranda would force the victims to give them their bank cards and PIN codes. These would be handed to accused 3, who would be accompanied by Barnett to an ATM to verify if the PIN codes were correct. Once it was confirmed that the PIN codes were correct, she would notify Miranda, whereafter the victims would be strangled by LaRue. The victims' bodies would thereafter be disposed of. The cards or money would be given to accused 2. All 3 victims died of ligature strangulation. The first person who was murdered by the group on 10th May 2016 was Anthony Robert Schofield. An amount of 16,600 rands was stolen. The second person was murdered on 26 May 2016 was Kevin Victor McAlpine. An amount of 1,300 rands was obtained from him. And the third person who was murdered on 30 May 2016 was Johanna Lateghan, and 3,000 rand was withdrawn from her account. The killing sprees came to an end after the accused were arrested in June and July 2016, respectively. At the end of the state's case, an application was made for their discharge in terms of Section 174 of the CPA, which I had dismissed. Brief reasons were provided for the order that I had made, and that judgment has been transcribed. Since the accused had been charged in terms of POCA, I decided that it was not prudent for me to have granted the application for a discharge at that point in time. Accused 1 testified in his own defense. He said that he'd met and married Michaela in 2010 while she was studying at Rima Church. They became involved in the courses KYE as well as KYS that was presented by Ria. He'd also known accused 2 when he was still young, and both of them stayed in Western area and attended the same congregation. He also met his wife, his friend Charles Trutter and his wife, being part of those teachings. Various other people, inter alia state witnesses, also attended this course. Michaela was told either by Ria or accused 2 that the Rima Church was run by Satanists, and thus she stopped her studies there. Ria introduced them to accused 2, and it said that accused 2 could see in the spirit whether they were clean. He experienced accused 2 as being a Christian in her beliefs. He has been a practicing Christian since birth. His contact with Ria ceased once he had completed the course. He suffers from chronic diabetes and uses insulin daily. If he does not use it, he would go into a diabetic coma. He said that he, Michaela, and the co-accused and other people were part of a group of friends. They would discuss the material from the KYS course and general religious discussions. He was aware that accused 2 came out of Satanism, but she told him that she was a reborn Christian. He attended high nights at least once or twice a month, when accused 2 would fall down and blood coming out of her mouth. They would then pray for her, as they were told that her spirit was taken to a ritual site. He had never seen any of her other powers being manifested. People in the group did get tattoos, more specifically the Electus Podeus one. He as well, but it was choice to do so. There was no hierarchy. He never stayed in accused 2's place. He was aware that she was very sickly, to the extent that he was aware of various hospital admissions. He had assisted in paying for in paying for the psychologist, who she visited weekly. He had stayed in Racketeering up and until a year after Michaela's death. At the end of 2013, he moved to Silverfields. Miranda and her children had visited him in Racketeering. For safety reasons, accused 2 would have spare keys to all his premises. According to him, the group were just friends and not a ministry. Accused 1 testified further that he resigned from Discovery in May or June 2015 and started this company called Entire Deity Trading, which would mainly involve forex trading. He'd also borrowed money on loan agreements from his parents and mother-in-law and would then pay them back on the investments. He'd used that money to trade with. None of the co-accused invested in his company. His income, even at Discovery, would fluctuate due to his line of business. At times, his bank account would be in overdraft. There was no time in December 2015 that he was blacklisted. He had 3 motor vehicles, but Miranda was leasing the BMW 318 from him. On leaving Discovery, he had to transfer his life policy from being an employee benefit into one of personal capacity. He made accused 2 his sole beneficiary. The policy fell into arrears, but he requested that the date of commencement be moved. LaRue started working as his personal assistant at Discovery in 2014, as Miranda and accused 2 had asked him to give him the opportunity. Due to this, LaRue had access to all his documents. During July 2012, he was still employed at Discovery and Michaela at Flight Center. He denied any knowledge of the happenings at Kelly Street, and due to the lengthy period lapsed, he could not specifically say where he was on those days. He further denied being involved in the manufacturing of the said devices. He was aware of the fallout that accused 2 and Ria had, but was never involved in it. Accused 2, according to him, never asked or instructed him to do something about that. Accused 1 testified further that he had met Natasha once or twice at accused 2's place, but had no personal relationship with her. He was never invited, or he was never involved or instructed to take revenge on her. During July 2012, he was either driving a black Opel Corsa or a gunmetal grey Opel Astra GTC. He heard about the killings of Natasha and Joy when it was spoken about at accused 2's place after it happened. He also read about it in the media. He had never met or seen Ben Dixon and only heard when he was spoken about. He denied murdering him. On the averment of LaRue that he and Miranda wore police uniform, he said that it would not have made sense since he would not have fitted into Dries' uniform. He also denied wearing a wig and going out to commit the murder. During that period, he had also received threatening messages, and some were said to be from accused 2's father, indicating that he should stay away from accused 2, as the Satanic Church wanted her back. Both his and Michaela's lives were threatened. He took these threats as an indication that they were actually achieving what they wanted to do by protecting accused number 2. They were also helping people who came out of the Satanic Church. Witches that wanted to hide away were sent overseas, and there was an orphanage that needed financial assistance. He did everything he could financially for the gain of the kingdom of Christianity. He estimated that his financial contribution towards this was 2 million rands. Monthly payments of between 50,000 and 70,000 would be made into accused 2's bank account. They were told that they were not supposed to see those children they were assisting, as it would lead the Satanic Church to them. He was thanked for his contribution via SMSs. The transfers were referred or were referenced as blessings. He also assisted in buying food for the group. He did not gain anything in return. Michaela had also assisted in buying things for accused number 2. Accused 1 testified further that he had a normal marriage with Michaela. After she had voiced the concerns that she no longer wanted to be part of the group, he was not part of or had overheard any plan to cut her off, as she was a loose end. She had said that she was feeling uncomfortable about certain things, and he had said to her that they should pray about it. And before they could discuss it, she was murdered. They were getting along quite well at the time. The things that she was feeling uncomfortable with were that accused 2 was lying about everything, and also that vast amounts of money that was given out. He was questioned by the police after her death, and they confirmed that he was at work during that day. On the day of her demise, he left her sleeping locked the premises as normal, and went to work. The markings on the cellar's door were not there when he left, since he had locked that door. When he saw it later, he took it as a sign of forced entry. When he came to the premises with the agents at about 14 hours, he had his own set of keys. When Michaela had returned the previous night, he had noticed that she had consumed alcohol. He never gave her any sleeping tablets. She had her own that she used with antidepressants. He explained that when he discovered her body, he had just remembered seeing white, and he totally freaked out and was very emotional at that stage. He had a cigarette, and the next thing he remembered was that there were people in white suits and police. In the beginning, he was very emotional, but he does not show it. It is the same with his parents, and in front of people, he keeps calm, and inside him, there was a lot of turmoil. He broke down after everybody had left. The same applied to Miss Lim, and he did not want to talk to her, and he was trying to keep his composure. At Michaela's funeral, he also did not deliver a eulogy, since he was scared of breaking down. He had displayed emotions when he had contacted his mother-in-law. He said that except for what he heard in court, he does not really know what had happened to Michaela. Accused one testified further that de Villiers came to stay with him at the end of 2012, beginning of 2013, for approximately 5 or 6 months. He denied that he had admitted to him that he had committed murder. He also denied having conspired to kill Joshua Groenewald. After he had seen him in court, he had realized that he met him during 2013 for business purposes. De Villiers had one day told him that his grandmother was sick, and he just panicked. He just packed up and left. They could not get hold of him again. His friends came and collected his personal belongings. He was not sure if any of his property was still at his premises when he moved to Silverfields. He could not recall telling him that he would end up like Michaela, but does recall accused 2 phoning de Villiers, saying that she knew what they'd spoken about. He said that he has no knowledge of a dry run taking place at his house. Accused 1 testified further that he'd asked Barnett for the contact details of Peter Meyer, since he wanted to approach him for business purposes. Peter Meyer had said that he was interested in making money to use towards a water park in KZN. He wanted him to teach him how to do the trading and wanted to do it himself. Their first meeting took place at the work premises somewhere in October 2015. About 2 weeks after that, he had a meeting with Peter Meyer at his house. Miranda and accused 3 were present. It was a continuation of their first meeting. He denied having seen Nicholas Meyer on that occasion. Miranda and accused 3 had just accompanied him since they were on their way somewhere in his vehicle. He agreed that he went to the mayor's house again on 26 November 2015 to continue with the talks. Miranda was driving the BMW 318. Accused 3 was present as they had picked her up from school. Peter Meyer could not make it that day, and they left. He did not hear the conversation that Miranda had with Peter Meyer over the telephone on that day in question. He denied any further involvement in either the scouting, planning, or partaking in those murders. He had mentioned that the 313 BMW was most probably at accused 2's premises at that time. He could not recall exactly where he was at the time of the murders, but does recall that Leroux was in hospital. Accused 1 testified further that he met Jared a month or 2 before 16 December 2015, when he came for help and he was addicted to heroin. He was going to do fly fishing and had booked at the Protea Hotel in Clarence. Accused 2 had also told him that he was stressed and he should go on holiday. He took money and luggage and was going to drive in the SLK. He had met Jared earlier that day at accused 2's place when Jared told him that he had problems with Nigerians and wanted to get a ride out of town with him. He agreed to drop him off along the way. Accused 1 said that he was bitten by something on the side of his head, went to the doctor and was given some medication. He was as well using his insulin. He was thinking of dodging Jared, but when he came out, he was there, so he took him along. This was around about 16 hours to 17 hours. Before he left, accused 2 had given him some juice, which he took along and drank it on the way. The last time that he could remember was when he was in Van der Bijl Park, and he drove through Van der Bijl Park and remembered losing total consciousness. And then he was in the 330 BMW, and they were just outside Krugersdorp. He was in the back seat, and Miranda, Barnett, and Leroux were also present. What he could recall is that Miranda accompanied him into the Herberg Hotel, and he was off balance and was very distorted and confused. He paid, and Miranda said that he should sleep there for the night, and they would speak to him the next morning. He was not aware of any pre-bookings and cannot recall himself booking in as Jacques de Villiers. Jacques de Villiers. The next day, Miranda and accused 2 came there and told him that people thought that he was dead. Accused 2 said that it was best to keep it like that because prior to him going on holiday, he had received threatening SMSs from the Satanic Church saying that the same thing was going to happen to him and his parents, like what had happened to Michaela. Accused 2 said that it would be best that he stayed in hiding, as people would believe that he was dead, and then they could not manipulate or threaten him. He felt guilty for not having protected Michaela, and did not want the same to happen to his parents, and he agreed with the plan. Accused 2 had also told him that they found a body in his car. He then put 2 and 2 together, and at that stage he thought that it was Jared. He was, however, more concerned about hiding to protect his family. He stayed in the herberg, and when the money ran out, he was moved to Tarleton. He also stayed there on the street. Ultimately, he worked and stayed at Kiakaha Ministries, where he was arrested on 26 June 2016. During the period he was in hiding, LaRue and Barnard would visit him and bring him food. Miranda had also given him a tablet in order for them to know where he was and to get hold of him. The money used for his upkeep came from his own properties that were sold. When this ran out, he landed in the street. As he had never insisted that they pay for him. LaRue also had keys to his flat in Silverfields from time to time when he'd left for Clarence, thus having access to whatever was inside his premises. At Kiakaha Ministries, he was earning an income. LaRue at first brought him the falsified ID document when he was in Tarleton at the end of January, beginning of February 2016. LaRue also told him that accused 2 had said that he should use it to obtain a job. He had never used it and thought that he had thrown it away. He had even used the name of Michael. Once employed, he heard from LaRue that they had claimed against his life policy. This is when he started to believe that it may not have been the Satanic Church, especially after he'd heard that his life policy had been claimed. LaRue also told him that at some stage they wanted to take his body and put it into a deep freeze to have the body identified for the claim. This would have been about 2 months before his arrest. After realizing that, he decided to get some money together and get out of the vicinity of Krugersdorp. He had no part in the claiming of the life policy. He did have contact with LaRue, only on the tablet to tell him where he was. He never received any SMSs or anything regarding what they were doing or planning. He said that he had no knowledge about whatsoever of the murders that took place after 16 December 2015. Accused 1 testified further that he knew Charles Maynard would approach him to rob a tab. He had refused, and that made Charles mad at him. He admitted that he was arrested on 26 June 2016 at Kiakaha by Warrant Officer Bester. He had agreed to apply for bail 2 or 3 months later. The affidavit that was used is Exhibit TDD. He explained how that came about. He had consulted with his then legal representative, and on the date of his bail hearing, he was given the affidavit whilst he was in the holding cells and was told to briefly go through it and sign it. He confirmed its contents in court. During consultation with his current counsel, he laid eyes on the affidavit again and realized that it contained incorrect information. He had stated at page 3 of the affidavit that he was driving to holiday when he was directed to pull off the road by an unmarked motor vehicle with blue lights. He pulled off and alighted and was pepper sprayed and ran away, leaving his motor vehicle behind. He stated that accused 2 visited him on 17 December at the hotel, and she told him that that was a story he had told them. He said that he believed her because he could not remember anything about that or anything before that. This was then the version that he gave to his lawyer in the bail application hearing. The affidavit does indeed refer to the threats he had received. And I'll come to accused 2's testimony. Accused 2 testified in her own defense and denied that she had continuously consulted a psychologist and had never seen Exhibit 5G. She denied that she is a Satanist and said that she's a reborn Christian. She does not possess any supernatural powers. She did not form any enterprise, and the tattoo of the Electus Badeus was coincidental and by choice. There was never any ministry. Prayer meetings and discussions on the Bible took place, and there was no ringleader. She had spent 90% of her time in a room, which led to visits taking place there. She was not involved in any murders. She denied that LaRue had to look after her. Accused 3 would sleep over to assist her if her chest closed up. She denied ever instructing LaRue to manufacture or build any bombs, and neither did she ever instruct any co-accused to throw explosive devices. Ria reported to her husband about an incident with packages and petrol, and she knew that Ria drove around with those things in her car. She only heard about the explosions from Ria and Dominee Henning. She has no knowledge of a fire at the Lighthouse Church. She had met Natasha only a few times and never told anybody that she was praying dangerous prayers. She never instructed accused 1 and others to scout Natasha, to use false number plates, and had never seen accused 1 with false number plates. There was no feedback after the murders of Joy and Natasha. She was informed by Rana about those murders. LaRue could have heard her telling accused 1 of that. She had never seen Ben Dixon and denied having instructed accused 1 and Miranda to kill him. She never supplied them with police uniforms. They would physically have drowned in Teresa's uniform. The only wig that she knows about belongs to her daughter and is green in color. She thought that a Colonel de Jager had told them about that murder. Everybody had spare keys of their premises. She denied that she had said that Michaela was a loose end that had to be cut off. She never gave Miranda the keys to go and kill Michaela. She denied any involvement in the incident of Joshua Groenewald. De Villiers purely disappeared out of his own choice. She said that she knows that Barnett had taken accused 1's business cards and gave it to everybody at his workplace. She denied having any knowledge of the Meyer murder and never got 600 rands to give to anybody. LaRue was in hospital during that time, and Barnett went to visit him there. There was never any discussion to fake accused 1's death. She agreed that at the stage accused 1's policy installments fell into arrears, and he had the cash to pay, but had no time to go to the bank. She took that cash and in turn transferred the money into the policy payments. She said that Jared never visited her flat, neither did she see him on 16 December 2015. She never crushed tablets into juice, neither was any bookings made at the Protea Hotel. She confirmed making various phone calls the next day in an attempt to trace accused number 1. It was LaRue who ultimately made the call to Discovery, since he knew all accused 1's personal details. That call was made because a policeman from Pietersburg had said that they should call about the car insurance. She never requested accused 1 to nominate her as a beneficiary of his policy. She said that accused 1 was having a bit of an argument with his parents due to him having pierced his ears. She denied any knowledge of a fake ID. She does not know any Chinese lady, and the firearms that were in court were never inside her flat at all, and were not in Miranda's flat when they were displaced. She has no knowledge of ammunition and never went to Miranda's school. She never used drugs, but LaRue did. She disputed Barnett's and Ellison's evidence. Miranda Stein was called by accused 2 as a witness. Her version had not been put to any of the witnesses when they testified. It is not necessary for me to deal with her evidence in any great detail. She clearly testified in an attempt to protect accused 2 and 3, which backfired after accused 3 had decided to come clean. She testified that accused 2 is a Christian whose life bears testimony to the fruits of the Spirit and is her very best friend. Electus Badeus is all about tattoos. They were only a group of friends with no leader. She denied any knowledge about the bombs and or the burning of the Lighthouse Church and said that LaRue's evidence was not true. She had met Natasha, and it was accused 1 who wanted to kill her, and Michaela became all excited about that plan. Accused 2 was never involved. Accused 1 later reported that they had done it, and her only involvement was to tell them to keep quiet. she never reported those murders. She then wanted to kill Ben Dixon since she had influenced Ria against accused 2. She blackmailed accused 1 in participating in that murder by saying that she would speak about the previous murders if he did not help her. She said that she and accused 1 were the only ones who were involved in it. They had dressed in SAP uniforms. Accused 1 had hit Ben Dixon with an axe, and she had stopped him, since she actually wanted to kill him, and had repeatedly stabbed him. Miranda testified further that LaRue was not telling the truth about Michaela's murder. She said that it was accused 1 who told her that Michaela wanted to go to the police, and also that he was suspecting that she was unfaithful to him. Accused 1 did not want to kill Michaela himself, so she did it all on her own. Accused 1 gave her the key and remote, and when she came there, he was still there as well, showing her that Michaela was sleeping. She said that she had no knowledge of the conspiracy to kill Joshua Groenewald. And what LaRue testified was not true. The Mayers were killed by her and accused 1 only. She'd answered the intercom when it rang. She suspects that the children of the Mayers had been involved as well, and that accused 1 knew them. She was left out of the planning by accused 1 and them, and they had perhaps shared the millions between them. LaRue and Barnett were not telling the truth about accused 2's involvement in those killings. She and accused 1 had an interview scheduled with the police on 7 January 2016. Accused 1 then in December decided to pretend to go on holiday. Jared was the victim that she, accused 1, LaRue, and Barnett had decided on. Accused 1's insulin was used to kill Jared because LaRue did not manage to strangle him. That murder took place because accused 1 did not want to do the polygraph test, and it was not to claim his life policy. She had dropped accused 1 off at the herberg where he had a pre-booking. She has no knowledge of the fake ID. She never financially contributed towards any orphanage, but helped various people financially. She also testified about the subsequent murders that had taken place, which is not necessary to repeat, save to point out that she had said that she was told by LaRue that some of the proceeds of the crimes were given to accused number 1. The third accused testified in her own defense. She said that she wanted to come clean and to tell the court the truth about what had happened. It is not necessary to repeat her evidence in full. She said that accused 2 had also made her to believe that there were orphans that needed to be taken care of, as well as adults who had left the satanic cult. On the intimidation and bombings charges, she said that accused 2 had their idea to scare off Natasha and her group. Miranda had built those bombs in her flat. On a certain day, she, Miranda, and accused went to the premises. She and accused went to the house, and accused got over the wall, and she passed him the packages with fertilizer. And he placed it in the yard, and after someone came out of the house, they ran away. She was also present when Miranda, Michaela, and accused 1 were involved in the setting light of the Lighthouse Church on 15 July 2012. A letter was also left at the gate. She said that accused 2 and Miranda were responsible for sending tracking SMSs. Accused 2 had told her that she had psychopath demons in her. On 11 July 2012, she, accused 1, Miranda, LaRue, and Michaela were involved in those incidences. She could not say who had made the bombs. Accused 1 and LaRue had thrown them into the yard, and this was on the instructions of accused number 2 and Miranda. Accused 2 had said that the bombs did not work, and children were still dying. On the instructions, a plan was formed to kill Natasha. She, Miranda, and accused 1 and Michaela were involved. The initial attempt failed. The actual murder was perpetrated by accused 1 and Michaela. During the report back, she had to wash the knife that was used with jig by accused number 1. She repeated the detail of what was said. Accused 3 testified further that with the Ben Dixon murder, there was also a prior failed attempt to kill him. She, accused 1, Miranda, and Michaela went, but she could not go through with it. He had to be killed because accused 2 had said so. Accused 2 had said that they were in a war, and those people had to be killed as they were turning against God. She had referred to King David as well. The actual killing was done by Miranda and accused 1, but she was also present. She had heard a grunt sound, saw Ben Dixon on the floor, and Miranda was stabbing him. Following this murder, they first went to clean up at accused 1's place. She said that Michaela had withdrawn herself, and accused 2 said that accused 1 had said that she wanted to get out of the group since accused 2 was lying and using them. Accused 2 said that they needed to kill her as she was loose string. Accused 2 had arranged with accused 1 to give Michaela something to make her sleep. She could not recall seeing accused 1 there on the day of the murder when they'd arrived there. They then entered the house. Michaela was asleep, and Miranda hit her on the head with a hammer and then started stabbing her. She had frozen at the door. She eventually went in and stabbed her on the side. She had pulled Michaela back into position and switched on the electric blanket so that the time of death could not be ascertained and they could have alibis. She did not resist those instructions as she was under the impression that she would be killed. This was later directly said to her as well. Accused 3 testified further that accused 2 also decided that Joshua Groenewald should be killed as he was closest to Ria. Ria could not be killed since she had accused 2's maternal rights. There were numerous stakeouts. Accused 1 and Michaela had once attempted to spike his drink in a bar, but it did not work. The plan was abandoned after De Villiers had left. She said that Barnett had mentioned the Meyers. Plans were made to either rob or kill them. She was with accused 1, LaRue and Miranda, when they visited their work premises, but she remained in the car. On the first attempt at the Meyers' house, she, accused 1, and Miranda went into the house, but could not do anything since their son and girlfriend were there too. On the date of the murders, she accompanied accused 1 and Miranda. She explained the sequence of events. She had answered Peter Meyer's cell phone, and told the person who was on the other side that there was a fight going on and that he should call later. A report back was made to accused number 2, and she thought that Barnett was also present. The money needed was to help the children and the ex-Satanists. Accused 2 had given some of the money to Barnett, and she and accused 1 had to take the rest to go and gamble. She had won 2,000 rands at the casino. The initial purpose of the group was to support accused 2 by praying. They were a social group who also got together to talk about God, and accused 2 would teach them. She saw them as a family. On the firearm charges, she said that as far as she knew, accused 1 obtained most of it, and Barnett had a contact, but she never really met them. She also said that LaRue hid it in her mother's flat, and he may even have been assisted by Barnett. She had started using drugs from 14 years of age up to her arrest. She had explained why she waited so long before she decided to speak the truth. It was contended on behalf of accused 1 that the state's case is based on the evidence of previous accomplices, which comprises both of direct as well as hearsay evidence, circumstantial evidence, the reliance of the doctrine of common purpose, and the provisions of POCA. It was contended that the blanket admission of hearsay evidence in terms of POCA and the Law of Evidence Amendment Act would render the trial as unfair. Reliance was sought in the matter of State v. Lovell and others, 2002, Volume 2, SACR 325 SCA, at paragraph 17 and 18. It was further contended on behalf of accused number 1 that LaRue, Barnett, as well as Miranda were all previously co-accused in this matter. Although LaRue, Barnett, and Miranda have since pleaded guilty on the basis of plea bargain agreements, the evidence should still be approached with caution, more specifically when having regard to the conditions of suspension of portions of their sentences, as well as the fact that they have benefited from the said agreement. Although none of them were witnesses in terms of Section 204 of the CPA, they had received lenient sentences on the prerequisite that they give satisfactory evidence against the current accused. Miranda, so it was contended, had ulterior motives to shield accused 2 and 3 from conviction. De Villiers had admitted that he was to a certain extent an accomplice to certain crimes, and the state did not request this court to warn him in terms of Section 204 of the CPA, and the same applied to Charles Maynard in respect of the alternative charges dealing with firearms and ammunition. When the court evaluates circumstantial evidence, it must be guided by the cardinal rules of logic set out in State Rex v. Blom, 1939 AD at 188. On the issue of hearsay, it was further contended that accused 1 was faced with a double-barrel shotgun when dealing with it. The evidence of LaRue, Barnett, de Villiers, Nina Scott Dawkins, Nicholas Meyer, Candace Ellison, and I.M. van Dijk contains hearsay evidence, and this comprised a reasonable portion of the state's case. The defense was well alive to the fact that the state would be invoking the state provisions, and at the onset of the proceedings, let me repeat, and at the onset during the evidence of LaRue, objected to the blanket admissibility of hearsay, and the state had considered that it would be depending on hearsay evidence, which was provisionally allowed. The hearsay evidence was allowed, but the court intimated that once it was appraised with all the facts, it would revisit the issue of hearsay, since not all the hearsay evidence was inadmissible. It was further contended that the bulk of the hearsay to which LaRue and Barnett were referring to would either be on the instructions that were given or reports back to accused 2, as well as certain contraventions that were overheard where accused 2 was involved. Accused 2 had denied the said conversations. Reverting back to the section 31B and C of the Law of Evidence Amendment Act, the question was posed where it would leave the court about the probative value of the hearsay evidence. The ultimate question remained whether the admission of the hearsay evidence would be in the interest of justice or would render the trial unfair. It was submitted that the latter rings true, and the court was requested not to add any weight thereto. It was further contended that the standard of proof is beyond reasonable doubt. In assessing the motives of a witness, it is fraught with certain dangers, and the court should not ask why the state witnesses have falsely implicated the accused. The way credibility is handled will depend on the prudence of the presiding officer. On the issue of discrepancies, the court must handle the discrepancies between the different versions of the same witnesses with circumspection. And it's up to the court to decide when evaluating all of the evidence whether the contradictions in the state's case is substantial or not. The contradiction in LaRue and Barnett's own evidence, as well as their contradicting each other witnesses were material and has to have a negative effect on the evidence. It was further contended that on count 21, which is the murder of Jared, no formal admissions were made by accused 1, and the state had to prove that the deceased died on 16 December 2015 as a result of injuries sustained on 16 December 2015 at or near Pieterstein, and that the body did not sustain further injuries when it was transported for the purposes of a post-mortem. On the issue of dog identification, it was contended that the evidence of Joshua Groenewald was relevant and that he did not attend any formal identification parade. He stated that a police officer called Knutzer had shown him a specific photograph of accused 1 and was not amongst the different people, and that he was told that it was Zach Valentine. In court, he was sure that it was the same person that he'd met, namely Mark. It was further contended that on the racketeering charge, that the state had not succeeded in proving that accused 1 had a conscious, deliberate intention to commit racketeering and the remainder of the charges. Further, that count 3, 4, and 5 are materially similar, and separate convictions would amount to a splitting of charges, as the overriding purpose was to intimidate. Similar arguments were raised on behalf of accused 2, as those that were made on behalf of accused number 1. This related to the issue of hearsay evidence, the racketeering charge, the doctrine of common purpose, circumstantial evidence, etc. I do not deem it necessary to repeat all. On the issue of count 1, it was contended that the state had failed to demonstrate the accused's association with an enterprise and a participatory link between the accused and the enterprise's affairs by ways of pattern of racketeering. An accused must have the clear intention to perform acts that are related to and which foster the operation or management of the enterprise. The commission of the offence of racketeering requires conscious and deliberate intent. The accused must have the requisite intent to commit racketeering. The test will be A. Did the accused subjectively foresee the possibility that his or her conduct constituted an offence of racketeering? And B. Did he reconcile himself or herself with that possibility? This, so it was contended, was not proven beyond reasonable doubt. On the issue of count 2, it was contended that it follows that accused 2 cannot be found guilty of managing an enterprise if the state had failed to prove the existence and operation of the said enterprise. The mere fact that a number of witnesses alluded to the fact that accused 2 was indeed the leader of the group and that most of the ideas and or planning with regard to the alleged crimes emanated from her, the failure of proving the existence of an enterprise as described in POCA cannot make accused 2 guilty of managing an enterprise. It was further contended on behalf of accused 2 that the state's case is founded on manipulation, deceit and greed. Many witnesses were called for the state, and a very large portion of the evidence revolved around either the occult and or religious issues. It should, however, be borne in mind that all this evidence do not purport to make out a crime in South African law. Even if overwhelming evidence were tendered that accused 2 was indeed linked to the occult and that she was extremely manipulative, she cannot be found guilty on the crimes she was charged with. This court has an obligation to ensure that sufficient evidence, which covers all the aspects of mens rea, are met before a guilty verdict can be advanced. The defense considered that prima facie, overwhelming evidence were portrayed during the trial, depicting, like I said earlier, lies, deceit, manipulation, and greed. The matter, however, cannot be decided on through emotional evidence. The fact remains that the matter can only be judged fairly if detailed legal principles are met. Further, that to establish the accused's guilt, the burden is on the state to prove sufficient mens rea, and as such mens rea covers all the elements of a crime. To merely be part of a group who committed crimes do not make an accused guilty just because of hers or his membership of the group. It is submitted that the majority of evidence where accused 2 were indeed implicated. Witnesses did not or could not describe detailed evidence of involvement. In the majority of instances, testimony revolved around "I heard," "must have been," "them," "they," "can't remember" detail. This lacuna resulted in the state's case to fail muster on all the elements of crimes charged with. With regard to the evaluation of witnesses, it was submitted that LaRue and Barnett were compelled to testify in terms of their plea agreements. Both have, on their own versions, lied previously under oath. It is questionable whether they have told the truth in this court. The defense considered that Miranda exonerated accused 2 and 3, but it is the court's difficult task to attach whatever weight, if any, on her evidence. The sudden change of version of accused 3, so it was contended, remained a challenge to evaluate, as it cannot be tested. It was further contended that the state bears the burden of proof to convince this court that the doctrine of common purpose was or can be imputed to accused number 2, and that the state had failed to meet the requirements to prove mens rea beyond a reasonable doubt. The version of accused 2 is one of total denial of being involved in the crime. It was contended on behalf of accused number 3 that the state has failed to prove that she was a member of an enterprise and or participated directly or indirectly in the affairs of an enterprise through a pattern of racketeering. There is insufficient evidence to prove that she benefited from the processes of any crime. There was no deliberate intention on her part, and she was acting under compulsion, which negatives intention to act in the manner alleged. The state had failed to prove that she deliberately committed illegal acts and has failed to prove account 1 and the alternative beyond reasonable doubt. It was further contended on behalf of accused 3 that there was no evidence that she was in unlawful possession of firearms and or ammunition at any stage during the commission of any of the offences. Any inference that she must have known about the firearms because she was present in some instances and therefore jointly possessed the firearms was not the only reasonable inference and was not sufficient to find a conviction on counts 31 and 32. A finding that because she was present during the shooting of her deceased and was guilty of the murder of the deceased in terms of the doctrine of common purpose would be incorrectly applied to counts 31 and 32 to find that she jointly possessed the firearms. She was not in possession of any firearm at any stage. It was further contended on behalf of accused 3 that the onus is on the state to prove that accused 3 was not compelled to commit the alleged offences as charged. No onus rests on accused 3 to prove that she was acting under compulsion. Her evidence that she was acting under compulsion at all relevant times was not rebutted by the state. The state had failed to discharge the onus in respect of the defence of necessity raised by accused 3. The version of accused 3, so it was contended, was reasonably possibly true and should be accepted by the court. She was at all relevant times acting under compulsion. As a result of this compulsion, she lacked the necessary culpability and, in brackets, intention required to sustain a conviction on any of the counts charged. The state has therefore failed to prove the guilt of accused 3 on all counts beyond reasonable doubt, and that she should be acquitted on all counts. These were the submissions made by counsel before me. It is right that the trial court must adopt a holistic approach in evaluating evidence, have due regard to the mosaic of proof in its totality, and accord due weight to all the evidence in the light of the inherent probabilities. In this case, see State v. Gadebe, 1989, Volume 1, SECR 422, SCA, at 426, paras F and H. The evidence should be considered holistically. Direct evidence as well as circumstantial evidence was placed before this court. Viewed in isolation, it may be insufficient, but viewed in the totality of all the evidence, it paints a clear and logical picture of the enterprise and its inner workings. In this regard, see State v. Souls and others, 1981, Volume 3, SA, 172A, at pages 182H to I and page 183B, where the court said the following. The state, and I quote, "The state is, however, not obliged to indulge in conjecture and find an answer to every possible inference which ingenuity may suggest any more than the court is called on to seek speculative explanations for conduct which on the face of it is incriminating. And when the accused misleads the court by lying, arguments based on improbable inferences are not calculated to impress a trial judge." A passage in a minority judgment given by Milan J.A. in R. v. Mlambo, 1957, Volume 4, S8727A, S738 is apposite. I may add that 2 paragraphs in this passage were cited with approval by Rumpf J.A. in State v. Rama, 1966, Volume 2, SA395A, at 401. In my opinion, there is no obligation upon the Crown to close every avenue of escape which may be said to be open to an accused. It is sufficient for the Crown to produce evidence by means of which such a high degree of probability is raised that the ordinary reasonable man, after mature consideration, comes to the conclusion that there exists no reasonable doubt that an accused has committed the crime charged. He must, in other words, be morally certain of the guilt of the accused. An accused claim to the benefit of a doubt, when it may be said to exist, must not be derived from speculation, but must rest upon a reasonable man and a solid foundation created either by positive evidence or gathered from reasonable inferences which are not in conflict with or outweighed by the proved effects of this case. Close quotation. The following was also said in State v. Reddy and others, 1996, Volume 2, SACR 1, decision of the Supreme Court of Appeal, at 9H to 10D. And I quote, "Subsequent to argument before us being completed, counsel for the appellants referred us to the case of State v. Chisane, 1975-3, SA 172, in brackets T at 173G to 174C, in support of the proposition that it is not mere speculation or conjecture to concede the existence of the possibility that the drugs found their way into the crates other than with the knowledge of the appellants. The case deals with the evidence of a single witness who was part of a police trap, and the evidence of an accused who was admitted to being in possession of a meager quantity of dacha, which she carried in her undergarments. The case is therefore distinguishable upon its facts from the present case. The remarks of the learned judge McEwen J. in the passage to which we referred must be seen in the context of the particular facts of the case which the court was concerned with. It's also noteworthy that the learned judge also referred with approval to the remarks of Deval J.P. in R. v. Herbert, 1929, TPD 630, S636, and Rumpf J.A. in State v. Gleck, 1973, Volume 1, SA34, A at 38H, to the effect that in considering the effect of evidence, one need not be concerned with remote and fantastic possibilities, and that it's not incumbent upon the state to eliminate every conceivable possibility that may depend upon pure speculation. The fact that a number of inferences can be drawn from a certain fact, taken in isolation, does not mean that in every case the state, in order to discharge the onus which rests upon it, is obliged to indulge in conjecture and find an answer to every possible inference which ingenuity may suggest any more than the court is called on to seek speculative explanations for conduct which on the face of it is incriminating. With regard to the splitting of charges, the following is said in State v. Dos Santos and another 2010 volume 2 SACR 382 SCA at paras 44 and 45, and I quote, "In a similar vein, Nafsan van Heerden JJA, writing for the majority in State v. Whitehead and others, stated, and I quote also, there is no infallible formula to determine whether or not in any particular case there has been a duplication of convictions. The various tests that have been formulated by our courts are not rules of law, nor are they exhaustive. They are simply useful practical guides, and in the ultimate instance, if these tests fail to provide a satisfactory answer, the matter is correctly left to the common sense, wisdom, experience, and sense of fairness of the court." Whitehead recognized that a single act may have numerous criminally irrelevant consequences and may give rise to numerous offences. Our legislature has chosen to make the commission of 2 or more crimes within a specified period of time and within the course of a particular type of enterprise independent criminal offences. Here, the 2 statutory offences are distinctly different, since POCA's substantive offences are not the same as the predicate offences. The state is at liberty to prosecute them in separate trials or in the same trial. Close quotation. With regard to the contradictions in the state's case, the court in State versus Nochakuvu, 2016, Zaska 112 at paras 8 and 12, said the following: "Be that as it may, it is common cause that there are discrepancies and contradictions in both the state and the defense cases. The question remains whether or not the said discrepancies and contradictions are relevant and material to the issue or issues to be decided by this court. The totality of the evidence sought to be considered holistically." In State v. Nkolo, 1991, SACR 95A at 98E to F, Nestor J. remarked that contradictions per se do not lead to the rejection of a witness's evidence. As Nicholas J., as he then was, observed in State v. Oosthuizen, 1982, Volume 3, SA 571T at 576B to C, they may simply be indicative of an error, and at 576G to H, it is stated that not every error made by a witness affects his credibility. In each case, the trier of fact has to make an evaluation, taking into account such matters as to the nature of the contradictions, their number and importance, and their bearing on other parts of the witness's evidence. The magistrate made a proper assessment and analysis of all the evidence by, amongst other things, weighing the strength and the weaknesses of the state's case vis-à-vis that of the appellant, including the probabilities and improbabilities. It is axiomatic that an examination of the probabilities can be done in a vacuum, or cannot be done in a vacuum. Such an exercise requires an analysis and evaluation of the evidence as a whole. See State v. M, 2006, Volume 1, SACR 135, SCA, at para 189, close quotation. In State v. Brainders and under 1998, Volume 2, SACR 432, SOKPA at 437G to I, Horn AG said the following, and I quote: "Ek is van mening dat ten einde 'n staatsgetuie te diskrediteer, sover dat sy getuienisverklaring betref, dit steeds 'n vereiste is dat daar 'n wesenlike afwyking deur die getuie van sy getuieverklaring moet wees, alvorens 'n negatiewe afleiding gemaak kan word. Nie wesenlike afwykings in 'n getuieverklaring sal nie noodwendig afbreek doen aan die gehalte van 'n staatsgetuie se getuienis as 'n geheel nie. Die doel van 'n polisieverklaring is om besonderhede van 'n misdaad te bekom, sodat daar besluit kan word of die beskuldigde vervolg moet word. Die getuieverklaring is nie om die getuie se getuienis aan die hof vooruit te loop nie. Dit is vergesorg om van een getuige te verwachten om in sy getuigeverklaring reeds presies dieselfde weergawe te verskaf as wat hy in die open hof gaan getuig. Sien aan die opsig die uitspraak van Klute R. en Shabalala versus Attorney General Transvaal and another committee and others versus Attorney General Transvaal 1995 Volume 1 SA 608T 199 and also 1995 SACR at pages 625 to F 625F to 626A. In state, close quotation, in state versus Mafaladiso and andere 2003 volume 1 SACR 583 SCA, it was stated at page 593F and 593I to 594B per Willowfield JA as follows, and I quote: Die juridische benaderingswijze tot weersprekings tussen die twee getuienis en weersprekings tussen die weergaves van een en diezelfde getuie, soos onder andere tussen sy of haar viva voce getuienis en vorige verklarings, is in beginsel indien nie in graad nie identies. Die doel is immers in geen geval om te bewys welke van die weergaves die correcte een is nie, maar om die oortuiging te bring dat die getuie kan fouteer, het sy weens defectieve recollectie of weens oneerlijkheid. Die blote feit dat daar self weersprekings voorhande is, moet hieraf met omsigtigheid benader word. Eerstens moet nauwgezet vastgestel word wat die getuie werkelijk bedoel het op elke geleentheid te sê, ten einde te bepaal of daar 'n weerspreking voorhande is en wat die presiese omvang daarvan is. In hierdie verband moet die feite beoordelaar in ag geneem dat 'n vorige verklaring nie by wyse van kruisverhoor afgeneem is nie, dat daar taal- en kultuurverskille tussen die getuie en die opskrifsteller mag wees, wat die correctheid van wat presies bedoel is in die weg staan, en dat die verklaarder self of ooit deur 'n polisiebeampte gevra word om 'n detail van in sy of haar verklaring te verduidelik. Close quotation. The doctrine of common purpose was neatly summarized in the matter of State vs. Mkhitaryan and others, 1989, Volume 1, SA 687A at 7051 to 706C as follows, and I quote: In the absence of proof of a prior agreement, accused number 6, who was not shown to have contributed causally to the killing or wounding of the occupants of room 12, can be liable for those events on the basis of the decision in State vs. Safatsa and others, 1988, Volume 1, SA 868A, only if certain prerequisites are satisfied. In the first place, he must have been present at the scene where the violence was being committed. Secondly, he must have been aware of the assault on the inmates of room 12. Thirdly, he must have intended to make common cause with those who were actually perpetrating the assault. Fourthly, he must have manifested his sharing of a common purpose with the perpetrators of the assault by himself performing some act of association with the conduct of others. Fifthly, he must have had the requisite mens rea, so in respect of the killing of the deceased, he must have intended them to be killed, or he must have foreseen that the possibility of their being killed and performed his own act or association with recklessness as to whether or not death was to ensue. Finally, when dealing with the credibility issue and the weight to be accorded to the evidence, I am enjoined to weigh up the evidence and to consider its merits and demerits, to decide whether it's trustworthy and whether, despite the fact that there are shortcomings or defects or contradictions in the testimonies, I am satisfied that truth has been told. In this regard, see State vs. Sauls and others, 1981, Volume 3, SA 172A. In casu, it should be considered that the first group of offences were committed during the period June 2012 to June 2013. That is approximately 5 to 6 years prior to the witnesses testifying in court. The second group of offences were committed from 27th November 2015 to May 2016. That is approximately 2 to 3 years prior to the witnesses giving evidence. The time lapse is significant and may serve as a reason for some of the contradictions between the state witnesses. Furthermore, the evidence does not relate to a single incident, but to numerous incidences, some of which followed in close succession to each other. This multiplicity of events and its proximity in time may also serve as a reason for some of the contradictions. In respect of most of the charges, the state's case is supported by circumstantial evidence. In respect of circumstantial evidence, it should be noted that it is not some lesser form of evidence, but simply a different form of evidence, as stated by Zulman A.J., as he then was, in State v. Reddy and others, 1996, Volume 2, SACR 1A, and I quote, "A number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish. Not to speak of greater numbers, even 2 articles of circumstantial evidence, though each taken by itself, weigh but as a feather, join them together, you will find them pressing on a delinquent with the weight of a millstone." Moreover, Wills on circumstantial evidence, 7th edition at page 46, and at paragraph 46, and 452 to 60 quoted and said the following, and I quote, "That network may be a more gossamer thread, as a light and unsubstantial as the air itself, it may vanish as a touch. It may be that as strong as it is in part, it leaves great gaps and rents through which the accused is entitled to pass in safety. It may be so close, so stringent, so coherent in its texture, that no efforts on the part of the accused can break through it. It may come to nothing on the other hand. It may be absolutely convincing. The law does not demand that you should act upon certainties alone. In our lives, in our acts, in our thoughts, we do not deal with certainties. We ought to act upon just and reasonable convictions founded upon just and reasonable standards. The law asks for no one, or asks for no more, and the law demands no less." Close quotation. The ratio of Hendricks J. in State v. Nkuna, 2012, Volume 1, SACR 167B, sets out the appropriate tests at paragraph 121 to 122 as follows, and I quote, "The evaluation of circumstantial evidence must be guided by a test of reasonableness. The onus on the state is not that it must prove its case with absolute certainty or beyond a shadow of doubt. All that is required is such evidence as to satisfy the court and prove its case beyond a reasonable doubt. It is right that the accused is under no legal obligation to prove his innocence. The state must prove the guilt of the accused beyond a reasonable doubt. In the case of circumstantial evidence, such as this one, I'm guided by the locus classicus case of R. v. Blom, 1939 AD 188, which sets out the cardinal rules of logic. They have to be satisfied when dealing with inferential reasoning. First, the inference sought to be drawn must be consistent with all the proof facts. If that is not, the inference cannot be drawn. And secondly, the proof facts should be such that they exclude every reasonable inference from them, save the one that is sought to be drawn. If they do not exclude the other reasonable inferences, then there must be doubt as to whether the inference sought to be drawn is correct." Okay. Is this a convenient time to take an adjournment until 2 o'clock?
Indeed, Madam.
We'll adjourn until 2 o'clock.
All rise.